game against Nicaragua.
Hello and welcome to episode 21 of the English Show. My name is Stephanie from Beltran Brito, and I'm accompanied by my faithful partner, Alexis. How are you doing?
I'm doing great. Welcome back. We missed you.
Thank you. I am riding a red eye.
We missed you so much.
The whole thing about why they call it a red eye is because your eyes are very red because you're exhausted. So if I'm going a little off the walls a little bit today, you know why.
You look amazing.
Thank you so much.
I am sure we're going to be just fine.
Came in on the red eye.
Yeah. Go watch last week's episode. You'll love it.
Did you guys talk about me?
What didn't we talk about?
You guys always talk about me because you guys love me so much.
We missed you. But let me tell you, were you here for the news?
What's the news?
Well, we already spoke about it last week. Got to watch last week's episode.
All righty. What news do we have for the audience today?
I mean, today, I don't think anything news really come up. Everything's status quo. Visa bulletin for April is current. There were great leaps and bounds there. We spoke about that last week.
Let's just touch upon it again because
sure.
This is the English show, just in case we have new audience members. So the phenomenal thing is with Visa bulletin, there was a dramatic change for the month of April, which is EB1, EB2, and EB3 are all current. I don't think I've seen that in at least 10 years. I don't think I've ever seen EB3 current.
I think there was a time EB3 was current. At least 4 years. I know that, but I'd have to go back.
Exceptionally rare for EB3 to be current. So for all three of them to be current is wonderful. Other workers did have a small jump, which is beneficial for those individuals who are other workers. But that's why I always push for PERM, always do minimum of an EB3. Other workers is just, there's no point. If you have at least 2 years of experience, you can qualify under EB3, right?
Yeah. EB3 skilled workers is the way to go.
Right, 100%. So phenomenal advance on the Visa bulletin, which means those individuals who have their I-140s filed and ideally approved can go ahead and file adjustment of status if they're lawfully within the United States with a lawful status.
So here's a thing that I get a lot right now. So it's just had the PERM approved or my I-140's been pending. Maybe I filed last month, last week, last year. Is it worth doing premium processing?
For PERM, I would.
Or is it worth just doing the adjustment of status?
Great question.
Right? And I always tell people, you already have the prevailing wage. We provided everything. I mean, this case is almost a home run. It's never a home run, but it's almost a home run. We're there. We're rounding the bases. Do we just go and file that AOS?
I like to have the surety of the I-140.
And I agree. And I don't like to spend other people's money loosely. But I will say having that I-140 approved is what gets you that a 99.9% chance of getting everything right with the AOS. You get a decision in 15 business days, and therefore we're mindful that you'll have time to qualify and get the AOS done. Hey, let's say there's retrogression, the Visa bulletin for the month of May. You still have time right now.
Yeah.
So I'm a big proponent of that. Now, if you feel very confident everything's going to be in, everything's okay, well, guess what? Just file the adjustment of status, maintain whatever legal status you currently have, get the I-45 rolling, and, call it a day.
I just like having in PERM, for you guys know this, I talk about on the show all the time. On PERM, I require my clients to do premium because it's just, I want that certainty that the I-140 is approved just in case things go sour with the company, just in case the company goes bankrupt, closes. Anything could happen with that company. It is out of your hands. Yep. So for me, I-140 phase for PERM is a mandatory must with premium. That's my humble opinion. But if you want to save yourself the money, you can absolutely just file the adjustment of status without the premium, but not my recommendation.
Yeah,
it's one of the few places where I say it's worth the money.
I agree. Do you have to do it? No. But is it highly recommended?
Yeah.
Oh, yes, it is.
Yes.
So we got that, I think, in the news. I know for some TPS holders, there's certain litigation that might end up going now to the Supreme Court. If it ends up like other TPS decisions, probably not going to end up well.
Yeah, I mean, not to be the bearer of bad news here, but Supreme Court already ruled on TPS. And essentially their essential ruling, and I think it might have been, was it majority decision? It was
Yes.
It was a majority decision, if I
course.
remember correctly.
Yep.
But like more than usual, you got me? Like it wasn't just like the three oddballs. I think a majority of them concurred that the leader, the general, the attorney, excuse me. Oh my God, I do this all day in Spanish, and I told you I was going to run into a wall today.
No, we're in English,
the
baby.
Leader of DHS, leader of Department of Homeland Security, which at the time was known, has the right to cancel TPS at any moment in time. And that is how we also understand it as well. So I would not put my faith in anything regarding the courts on TPS. I would be cognizant and be making other alternative decisions, which include potentially EB2 NIW filings, 245K, which are self-petitioned without a company. I think you guys really need to consider that because 245K permits you up to 180 days without unlawful status. That's something you really need to be considering instead of putting your faith into the courts and the TPS, because I just don't think it's going to happen.
Absolutely. Absolutely. I mean, there are options. That's the big point. Right. But nothing is guaranteed right now.
Right.
And that's the main concern. Do you want to just jump into the Q&A?
Let's jump into some Q&A. As a reminder, I guess, for those of you that are watching, we typically do this show in Spanish, which is why sometimes me cruzan los cables. Sometimes I speak English, sometimes I speak Spanish. We're used to doing the show in Spanish on Thursdays at noon, where we answer all your questions about immigration live. So any questions you may have, this is literally a free resource. Ask us questions about immigration. That's what we are here for. But yeah, let's go to the questions.
We'll probably respond.
That's
no matter
what I heard.
What
I heard is that whenever I leave Gil and Alexis to their own devices, they just start answering random questions that have nothing to do with
We get great questions, and there's nothing to hide.
Yeah, don't ask me random questions. Only ask me about immigration, okay? All righty. So let's go. You want to start?
Sure. Let's take it from the top. Here we go. So Wayne H.E. asks, hello. Hi, Wayne. For tourists who enter on a B2 and stay more than a month, do they have to report to USCIS now? Thanks. You're reporting, do you mean more than a month than your entry or more than a month than the I-94?
He was referring to he's referring to like if he comes in his I-94, does he have to do alien registration requirement? But alien registration requirement, you don't have to do it because you have an I-94.
Exactly. That I-94 serves as the alien registration requirement. There are many things that when you do or perform a certain task, automatically are that registration, if that's what you're hinting at. Oh, yeah, the 30 days after entry. Mm-hmm. So, or within 30 days of entry. So you're fine as long as that I-94 is updated and issued. If it's not, and this has always been common practice, you should contact CBP to make sure your I-94 is updated. So when you enter within a day, that I-94 online should be up to date, maybe even a couple days. But honestly, I wouldn't wait more than that. You want to make sure that CBP has updated it. We don't always get our passport stamps. That's no longer a thing. I kind of miss it. I kind of like to see the stamp.
Oh my God, I know. The place that I went to, which is why I came on the red eye, didn't stamp my passport, and I was so bummed about it.
I feel like you have to ask nowadays.
I was so bummed. I was like, please stamp my passport.
They told you no.
I didn't ask, but they didn't, and I was so upset about it.
I know. I'm like, why do I need a passport? If it's not for the stamps, then what? But always ask to update the I-94.
But yeah, so the misconception is alien registration requirement made it seem like everyone who has been in the United States for 30 days has to register. Really, that's not the case. It's for people who hadn't registered. But by entering through a lawful port of entry to the United States, your entry was registered. It also is very relevant for individuals, for instance, that turn 14 years old while they're in the United States, because they likely were never fingerprinted.
Exactly.
And once you're over 14, then you do have to fingerprint. So if you're like a 13-year-old turning 14, and you're going to spend more than 30 days in the U.S., that's when you have to consider alien registration requirement for fingerprint purposes.
Sure. Maybe you've been F2, right? Your parents in F1, you're in F2, parents on E2 and L1, H1B, and there's a derivative beneficiary. Once they come of age for registration, so that's 14, then you do need to report it that way. And usually what they do is they assign a biometrics appointment for you to go, for that person to go in and get that done.
Alrighty, let's see. I've got a question here from Christian from Instagram. I mean, all the requirements and qualifications for the O1 visa for artists. Beautiful. But my previous visa was canceled because it was discovered that I worked for a few days during a prior visit. Yikes. Is it still possible to obtain it? So Christian, what's going to happen is as follows. If they find that you worked unlawfully in the United States, typically, even if it was for 1 day, they're going to subject you to a 5-year ban. Okay. So I don't know when they canceled your visa, but try and count it roughly from that time. Technically, it should be counting 5 years from the day you left the United States, but it could be from the moment that they canceled your visa. You may want to send me the information just to verify. Now, after your 5-year ban, you can apply for the O1 visa. I have had success. They've issued my O1 visa without them even asking, because the officer noticed that 5 years had passed, so they didn't even ask me. But I have also had the situation, particularly more with this administration, where they saw that the 5-year ban had passed. So it had already been 7 years in this person's case. We applied for an O1 visa, and the consulate did ask me for explanation. So we sort of submitted an affidavit from the person that said, hey, listen, I'm sorry. It was a blip in my decision making, but now I abided by my 5-year ban, and now I'm following the proper mechanisms. We reapplied for the visa, and it was issued. So there's just like an extra step you have to take. I wouldn't even apply if it's not before the 5 years.
Yeah, I agree. I'm going to skip one here, leave that one for you, but I'm going to go with another one from Instagram. And we have Edgar Solorzano states, my wife and I are pending for an O1, done with our firm. Yeah. All right, cool. And my daughter has a volleyball tournament next week in Atlanta. She's born in the U.S. Risk of traveling with her next week. If you have a valid B1, B2, or a previous O1, whatever it might be, it's fine. O1 visa, non-immigrant visa, it's still pending. They might ask you about it. Just let them know, hey, yeah, I'm aware of that petition's pending. If you're entering as a tourist, I'm coming in here for the volleyball tournament. Take some proof of that, and that's it. Enjoy the tournament, and good luck.
Okay, so, but Edgar kind of brings up a certain point that maybe we want to discuss, right? So there are reports, as you guys are aware, because there is no funding for TSA, which is a governmental entity, there are less TSA agents because less of them are showing up to work.
Of course.
And so what this administration is doing is they're deploying ICE agents to serve as assistants at TSA. Let's not even go into what I think about this, because Alexis will not like it. But
I never said I didn't like it.
Alexis will not. No, you're gonna agree with me.
Oh no,
you're not gonna like that I'm saying it on YouTube. You're gonna be like, Stephanie, don't say this on YouTube.
We could talk about it. It is interesting.
Silly.
It's interesting.
I think it's a mechanism to test.
An enforcement agency is there, but it is filling a need. Have you seen the lines at the airport?
Well, I came in this morning and it was fine, so thank God. But
good.
That's what I was gonna say. Miami doesn't have ICE agents yet.
Not yet.
Mm-hmm. So the ones that are reporting, the reason I'm bringing it up is Edgar is saying Atlanta, and Atlanta already did report ICE agents.
Exactly.
And so it's a couple of things, right? I will give my humble opinion here. I think they're using it as a testing ground for deploying ICE agents eventually to the polls.
I don't think so. Okay, we'll talk.
I told you Alexis wouldn't want me to talk.
To do with immigration.
I'm testing theory. I told you he wouldn't want me to talk. But anyway, the idea is they have no familiarity with the scanning. They have no familiarity. There have been images in airports where it's just an ICE agent standing behind the TSA as if to say, I'm going to monitor your work. So they're not being helpful in any sort of way. It's actually leading to more delays, in my humble opinion, because they're asking for things that typically they don't need to ask for because of just their unfamiliarity with the situation. But that being said, because Atlanta is one of the airports that it already is confirmed that ICE agents are at, I definitely want you taking a copy of your receipt for the O1s and the O3s. Take copies of the receipts for everybody. You should not have an issue. If you have a copy of your I-94, take that as well, so you can show that it was timely filed, right? So if you...
Well, I'm assuming they're traveling into the United States.
No, they're traveling domestically because an O1 is pending.
The O1's pending. I just don't know if it's extension or if that's... but let's assume it is a change of status, which would be the riskier of the two, right? If you're entering in the United States from consular from abroad, then it's not a problem. But assuming it is the change of status or an extension of status, absolutely. Number one, everyone should always carry their I-94 on them. Let's just start with that. That's just common practice. You need to have that. A copy of the I-94, always. And if it's changed due to an extension of status or a change of status, you need to take that approval notice, acknowledging
or receipt notice.
In this case, if it's pending, take the receipt notice, and you should be fine. But yeah, it's a domestic flight. Everyone that's traveling domestic, guess what? Now you might have an officer asking you questions. Tell people all the time, take the documentation with you, have it on hand. Because guess what? You are legally here in the United States. I'm assuming. If not, you wouldn't even be trying this. So enjoy the trip and good luck in the tournament.
Yeah. Oh, wow. I see why you left this for me.
Do you want me to read it
Most
to you?
beautiful attorney, Stephanie. Thank you. Andres Escobar. Oh, I recognize that name. Could you tell me when I will receive my work permit? I filed for an adjustment of status for my EB2 NIW on December 12th, 2025.
Oh.
Andres, I'm trying to recall if you're Colombian or Venezuelan. I think Andres is Colombian. Colombian adjustment of status, EAD. Honestly, I'm seeing them in like, it is taking a little longer because I am usually seeing them within about 3 months. So what is it saying officially?
I want to say it's like 6 to 8 months.
Tell me SCOPs.
Yeah.
Just comparatively. We're looking it up, Andres.
Yeah.
Oh. So officially they're saying 7.5 months, between 7.5 months and 9.5 months. Honestly, I'm seeing it in roughly 3 months. But unfortunately, what does that mean? I typically see it about in 3 months. But if I don't get it in 3 months, I technically cannot make a formal complaint until 7.5 months have passed, roughly. So it's hopefully we get it very soon, right? Or hopefully you get it very soon. But if you don't, there's no proper mechanism to do a complaint until about 7 to 9 months from now.
Exactly. I mean, listen, they generally take that three to 4 months, maybe 6 months. Things are a little different now, and unfortunately, there's nothing that can be done at this point. But just be mindful that kind of updates every 30 days as well. Let's go with Katya. How about an EB2 NIW via the consulate? I-140 is not approved yet. Priority date is March 2026. So you just filed. Would you recommend paying premium processing to get consular appointment earlier since it's current in the bulletin? I mean, it's up to you, right? So that I-140 decision is still going to be made here in the United States with USCIS. You could do that, have a decision within about a month and a half, 2 months, right? And if it is approved and the bulletin's still current, the visa bulletin's still current, you'll probably hear back from NVC within 30 days, generally, after the approval, maybe 60 days, and then formally start the process thereafter, and that might take about 6 to 8 months. Depending where you're from, maybe there's a hold as well. So I would say if you're from one of the countries with a travel ban or a partial travel ban, immigrant visas are currently on pause, then I'd say maybe it's not worth doing it just yet until you know that it is possible. Because what benefit will there be if you can't have one? Now, there is the argument of, well, the pause might end within the next 6 months, right? I mean, we hope for clarity by the end of April, by the way. And so if you're already getting the premium processing and you get a decision, even if the ban's still in place, you can start stage 2 with the DS-260 and get that in and just wait till the very end and at least put your place in line so there is that point. It's completely valid. I think it's a matter of just personal discretion. If you feel that you have a good case and you've prepared and submitted one where the endeavor is very well documented, then I think it's worth it. If it's not, then maybe you want to wait and write it out a little bit. This is very subjective. It really depends on the officer that has your case right now. I'd say for EB2 NIWs. So, I mean, it's a good strategy, but I would say it would depend on the strength of your case.
So Edgar gives us, it came in? Yeah. I figured it was this. Because I think I've heard about your case internally, Edgar. We've been here since 2016, tourist to students to TPS to O before November 7th, just to add my traveling to Atlanta question. So yeah, I want you to basically take the copy of your I-94, the copy of your approval to F1, the copy of your approval to DPS, and the receipt to O1. I want you to have digital copies of all of that to show that you have always maintained lawful status. Have those copies on your phone.
Absolutely. Absolutely. Yeah. It's a rough time. It's a rough time for people. I mean, guess what? We see people at USCIS make an incorrect decision of, hey, TPS is in a status. And we're like, what?
Which
Do
actually,
you know the rules? Do you know the law? Have you seen the regs? It absolutely is. And that's not a matter of discretion. That's in there.
Speaking of, so I'm going to jump into Wayne. Okay. I've seen people who are receiving NTAs, court orders, because TPS Venezuela was terminated and said their status expired on September 10th. They aren't recognizing through November 7th. Do you know anything about it that you can share? So you're perfectly fine. It's through November 7th. It is official. It was stated by NOM. Literally, there is a statement from NOM that says Venezuela TPS expires on November 7th. So I'm 100% confident on that one. The notice is going to say September 10th, but there's a very clear argument that you've got November 7th. You're fine.
Due to the litigation.
No, not due to the litigation, because NOM said it ends on November 7th.
Thereafter. It was originally November 10th, and then she gave the additional time through November 7th.
She said
for TPS 2023.
For the one that started in March 2021.
21?
Right? She explicitly states her notice to terminate
is November 7th.
And that is the final date. So that part is not subject to litigation whatsoever. Correct.
But then the 2023 has a different date.
Correct. Yeah, I'm talking about 2021.
Yeah.
Stop confusing him.
Anyway. Confused?
No, that is not subject to court litigation whatsoever. Right? Zero, none. The November 7th date is not subject to litigation. That is officially the date that NOM said that Venezuela TPS was going to end. So, what does that mean? If you get an NTA, a notice to appear before court, as long as you filed a change of status prior to November 7th, and you can show that to the officer or to the judge, you are perfectly fine and they shouldn't have any sort of issue, right? Thank God, I'm not even going to keep talking about it because I have not gotten NTAs. I know Gil has, but in those cases, they have officially gone to the court. They showed that they timely filed a change of status and it has been perfectly fine. Judge has said, okay, great. Let's see what happens with that case.
Yeah.
But
the September date is the 2023. That's what's happening. The TPS.
Are you continuing to confuse people during my question?
There's no confusion. There were two
What is the date?
That's November 7th for TPS 2021.
For the 2021 group.
Now the 2023 group was September.
No. The April 2nd group
was protected
until technically October.
September 10th, 2025 was the designation date. And then it went to October because of litigation. So I think what we have to concern ourselves here with is it depends what the people who are receiving NTAs, what TPS do they apply for?
This man said 2021.
I know, but he referenced September and is referencing people who had TPS. So some of them have 2021, some of them have 2023.
The April group was through October, not through September.
It was originally through September.
No.
Yeah, it was originally through September, and then it became October thereafter. But it was the original expiration date was September 10th, 2025.
That's the 2021 group.
You just said 2021 is November.
2021 group
is November 7th.
Was September 10th. Which NOM moved to November 7th.
Exactly.
2023 group
was always October.
Was April.
And then they gave him the 6 month through October.
They didn't give him the 6 month to October. The courts gave him the 6 month to October through litigation.
So then,
but that's not this guy's case.
So
this guy is belonging to the 2021 group.
So the 2021, to go back to my original point, it was originally September, and then it became November
7th
due to NOM's standing, which was an additional like 60 days that they gave. I know you said that. Oh my goodness. We came to the same conclusion after all that. All right.
That's exactly what I said.
Yeah.
You just confused everybody.
No, it's that he doesn't say 21, 2023. It just depends.
But he's saying September 10th, so he's very clearly the 2021.
Yeah, I'm assuming he's referring to the 2021 group. Listen, the thing is with those NTAs though, that's something that they need to bring up in court, where it's essentially you've already received the NTA, right? Mm-hmm. So that's DHS's stance on the matter. Now you need to present to the immigration judge why DHS is wrong in their interpretation and say, hey, no, it's November 7th. Why? And then if you've filed something on time, I would say before November 7th, that constitutes a timely filing, and that person should not even be in immigration court.
Correct.
And it's unfortunate because the time, the resources, and the money that people need to spend, and the government, by the way, on cases that shouldn't even be there to begin with is just absurd. You still on that red eye tip. Oh my God. Here we go. So you skipped a question, but I'll take it here. And so we have Evelyn. What's the typical wait time for an I-751 application? We're close to 3 years at this point. Actually, it used to be about a year or two, and then every few months they'd add a few months to the process. Right now, officially, it's 3 to 4 years, but we're getting responses in within about 3 years.
I just looked up official dates for you.
Yeah, it's like 48 months, no?
Officially, they're saying 28.5, but you can't make an inquiry unless your date is prior to July 2023.
Exactly. So it's essentially the 3 years. And so figure out your exact priority date, mark it, put it in. If you can do it, just file the service request. In December, it was at 47 months, I recall. And it just so happened, though, this year already, we've received 2 requests for evidence. Basically, they just want additional evidence that the couple are still married, obviously because they filed this about 3 years ago. So, Evelyn, if you haven't received a decision, I would say it's time to check. But it's startling. A lot of people could technically file for citizenship, and they don't because they need to get the conditions removed. And I mean, there's a little bit of a workaround that's discretionary, but at the end of the day, you still need to remove the conditions. So at this point, definitely look into filing the service request.
Kush asks us, do you have any information on how long USCIS is taking to issue receipt notices on I-140s? I usually get it within 2 to 3 weeks, maybe a month, but maybe like 2 to 3 weeks.
Maybe a month if something gets lost in the mail. But how do you try to get a receipt notice now if they don't accept checks anymore, right?
I know, that's the bane of our existence.
It's always I think you have to call USCIS and still kind of struggle to get someone in order to try to get that receipt notice if you haven't received it in the mail.
There's a form that I've been doing for mine. Remember what it was? It was like the notification of case creation.
Isn't it G1055 or one of those? No.
G1145.
1145. Yeah.
Which is like you get an email when they accept your petition and they give you the receipt number. I have been using that one when I'm like really, really stressed.
Mm-hmm.
So maybe that's an idea. But obviously I'm assuming you're asking the question because you already sent your I-140. So that's a little too late.
Exactly. Here we go. Let's go.
Italian pequeño.
This person clearly was happy with either the Venezuela or Italy winning.
We won either way.
Exactly. World-based classic talk.
Hilarious.
IG is hot with questions, huh? You are the Italian Tequeño.
I'm gonna make that my new nickname.
I mean, I thought this was you. What path do you recommend? Tourist visa and F1 or tourist visa to O1? I mean, it just really depends on how strong your case is before you even enter the United States, right? And I think that's why in last week's show, we spoke a little bit about strategy, like the timing of filings. And I think that's why it's important before you even decide to enter the United States, have that conversation with the attorney. Because if you have a really good case, then come in B2, 90 days. If you think at that point it's right, then, we could file an O1 if your intent changes right after those 90 days. But if you need to study or it's just not the right time for an O1, yeah, maybe an F1. But by the way, being on an F1 doesn't really help you for an O1 either.
Right.
Because you can't work while you're on an F1. So usually what I would recommend is come when you're ready for the O1. Or do the O1 from the beginning.
Do you need to work or not? If you need to work, F1 is not a realistic option unless you have 0 work experience, you're coming to get a bachelor's, and then you're counting on getting OPT,
CPT,
OPT, STEM OPT. You want to do work experience, and you want to take that route. That's a very common route. You come in, tourism, F1, you study a degree in the United States, whether it be bachelor's or master's, PhD, you get OPT, you work in the United States, you go on to H1B or O1. Very common route. But if you are coming and you want to work from day one, you need to go O1.
Absolutely.
And you need to qualify for O1 because F1 just does not give you the ability to work. And that's a big thing in the US.
Absolutely. It doesn't help you. So it's a little bit about strategy. Italian
Tequeño.
Look at this. Jasper. The young lady looks fantastic.
Well, I'm not very young as of yesterday.
Very, very young. What's up to you? I just did Italian Tequeño. What do you want?
Oh, Allie, if you want additional information, you can go ahead and write to us, beltranbrito.com/contact. It's beltranbrito.com/contact. I think it's somewhere here. They'll put it somewhere here. I swear. Just contact us. There it is. Right there, right there, right there. All right. So we have a relative, Emma, who has been waiting for the oath ceremony since November 15th. Is it normal? A couple of questions, Emma. So my N400s are going extremely fast. Can you tell me the official wait time?
I'll check it out.
It's extremely fast. I'm talking like in 2 months, I'm already having my swearing in and my ceremony. But is this person from one of the countries with the partial ban? So if they're from one of the 19 countries, these N400 applications are on pause per the Trump administration. I think the most common being on that list is Venezuela. Obviously, that's the one we kind of most deal with us on the show. But 19 countries ban. Let me just list some additional ones so I could tell you. Like Eritrea, Haiti. We deal with a lot of Haitians, Venezuela, Syrians. So if you're from one of those countries, then your N400 adjudication will be paused. So you just have to continue to wait. If you're not from one of those countries, what's official processing times?
6.5. I think, anywhere between 6 and 8 months, even though the majority are 3 months.
The majority is. Yeah. I got one. I got the ceremony 2 weeks after filing.
That's
Yeah.
Like,
so it's just, once December, January, February, March, April, May. So once June comes, if you still haven't gotten a response and you're not from one of the paused countries, then you can go ahead and file a service request.
Absolutely.
But if you are from one of the paused countries, you just got to keep waiting.
Yeah, just go for it. Here we go.
Let me do that one.
Yeah, you want?
Sorry.
All right.
Continue. Wow. I need a lot of these actually.
We'll take it out. Here we go. Salvatore Castano. Whatever happened to that lawyer who used to say, "Be patient. TPS is here to stay." Clearly, that lawyer is not here. Wait.
And we would get so upset with that guy.
Yeah.
We would get so upset with that guy because people would call us and be like, well, but there's some guy on the internet who's saying, don't worry, TPS will be there forever and we'll win all the lawsuits. And it's like, and we kept telling them, you need to plan for something else. It's not, it's temporary. It is literally in the title. How many times did we say that in our lives?
Forever and a day. And it's unfortunate because I love TPS. I thought it was a great stepping stone for many people. Right. It was a benefit to transition, especially for people that were coming from countries that are truly going through some sort of major turbulence. It's not like, hey, one part of the country. No, the entire country. And that's why TPS is very selective. But at the same note, it's not forever. It's certainly temporary. Not only does the title say it, but they grant it for 18-month periods, 6, 12, or 18-month periods. Generally it's 18 months. And so we always said it like, get into it so you can get it, be in it, status, get yourself figured out, but prepare yourself to get out of it. Don't know who that lawyer was, never cared to find out because I don't worry about how others do it unless they're doing it the right way. And then, of course, we want to learn and do better always for our clients. But yeah.
What happened to exactly that? It's a temporary protected status. It needed to be used as a stepping stone. That's exactly what it needed to be. Let's see. So Erica, I know Erica, which is why I wanted to answer. Can my mother as a permanent resident file Form I-130 and Form I-45 at the same time for my 17-year-old sister who has been in the United States on a tourist visa since December? Assuming the I-94 was January, February, March, April, May, June. Assuming the I-94 is June. We've got Visa Bulletin F2A.
Current?
No.
For April.
Is it?
Yeah.
That one was current too?
Mm-hmm.
I was only paying attention to EB123. So January, February, March. So she already hit her 90 days.
April.
That means in April, yes, she can go ahead and file Form I-130 and Form I-45. We need to do it in April, Erica. We must do it in April because that could retrogress again, even though F2A has actually been a really forgiving category for like the better part of 2 years, which has been incredible. Must take advantage of Visa Bulletin, file in April, concurrent I-130, I-45.
Remember, it was about like that week, which really ends up being like a month.
Yeah.
And then it became current. And it's
amazing.
Like, yeah. I
amazing.
had a few clients taking advantage of that. Let's see. Okay, just for those of watching and who don't speak English, Fernandito, recomendaciones para los que no sabemos inglés y pretendimos emigrar al norte, tengo miedo. So for those who don't speak English and want to know more about migrating north, I guess you're in the South, and you're fearful. Well, Fernandito, that really just applies to anyone in general, and I can see that it is a volatile time for many people because it seems scary. But at the end of the day, what I would say is what's happening is they're being, by they I mean the U.S. government, is being strict on its process when it comes to immigrating to the United States. Maybe it's stricter enforcement, stricter interpretation, but it's impacting mostly those who have entered unlawfully or who entered lawfully and overstayed. And so if you're doing things right from day one, I wouldn't worry about a fear. There is nothing to fear. It's more of just preparing and doing the best case possible to be approved so you can enter legally and maintain all the status as it should be from day one. Fernandito, if you want that in Spanish, on Thursdays, we do the Spanish show, 12 o'clock Eastern Standard Time. Si quieres vernos los jueves a las 12 de la tarde, horario de Miami, hacemos el programa en español y nos puede ver y seguirnos, pero no debes de tener miedo si desde el día 1 estás haciendo todo de la manera correcta.
And you also don't need English for visas nor for permanent residency.
Oh, sure. That's a good point. If you're considering, does knowledge of the English language, is that a requirement? It is not. Not until you apply for citizenship is knowledge of the English language a requirement.
Nope. Jaime. Hi, Lori Stephanie. I'm currently with O1 visa that expires December 2027. How long before it is advisable to do the renewal, or what would be the other visa option that I could apply for? So Jaime, if you qualify for an EB1, for instance, and you're interested in permanent residency in the United States, you may want to have a call about EB1 permanent residency. That's a very common route after O1. So a lot of my clients will come in on an O1. They'll figure out if they like it or not, if they want to stay or not. And if they've decided they want to stay, they'll usually apply for an EB1 permanent residency. I call it the O1 on steroids. So if for the O1, I needed 2 press articles, for the EB1, I need 5 press articles. For the O1, I wanted 1 award. For the EB1, I want at least 2 awards. So it depends, and really depends on what you do. But it is a more extensive version of the O1. And so that you could go ahead and do that. If you're going to do an EB1, I'd like for you to start already now so you can document it and get hopefully your approval and adjustment of status already well filed before December 2027 and never elapse in time in your ability to work. If you haven't decided whether or not you want to live permanently in the United States and you still just want to extend your O1, or if you don't have the evidence for an EB1 just yet, consider doing your extension. I would say December 2026, 1 full year in advance, because regular processing O1 is currently taking about 10 months. So if I start the case in December, I file the case in January, February, I can get a decision and save the money of premium processing so I don't have to spend the money on premium processing. So I would say contact me in December.
Absolutely. Here's an interesting question from Jesse. Hi, according to the circumstances, do you think that there are more approvals or denials for EB2 NIW? I think there's still more approvals. At least internally for us, there are more approvals. Now, has the number of denials in general for EB2 NIW increased in the last, year or 2 years, maybe, just progressively? I think so. We know so. If you look at the official figures published by USCIS, they are. So that's why I think more than ever, it's very important to have a clearly defined proposed endeavor, be in a position to deploy or implement that proposed endeavor, have potential clients or investment to help get that proposed endeavor going. It really matters. I think it really matters, where before you'd get a case approved just with a simple 2-page statement. That's not the case anymore. And so are there more denials? Yes. But in terms of comparing denials today to denials yesterday. But are there still more approvals? There are.
I would also add here, because of this administration, because denials are a little bit increasing, I think it's more important than ever to always maintain a non-immigrant status. So when the statistics start to change a little bit and you see a bit of an increase in denials. I deter from individuals filing concurrently, which a lot of people have been asking about. Now that it's current, should I file concurrently? I deter from that. I prefer to be very conservative in times like these, maintain lawful non-immigrant status, whether that be F1, B2, O1, H1B, whatever it may be. Maintain that lawful non-immigrant status until you get your I-140 approval. Just be a little more conservative in times like these versus filing concurrently. I only file concurrently in sort of extreme situations like an age-out child.
Absolutely.
Yeah. You want to go to the questions? Digo, you want to go to our topic?
Just really quick.
Wayne's
Wayne's worried.
I
No
know.
peleen. We don't.
Wayne,
this is not us arguing.
No. I knew that. He didn't know that. I knew that.
Okay.
I knew.
I was gonna ask for an air hug, but
no,
that's fine.
Because I knew. He was like, oh, but if he's 2023. I know. I understood Wayne. Wayne and I are right here.
This is just how we operate.
We fight all day long. Don't worry about it.
I don't think it's fighting. I think it's love.
It's siblings.
It
Sibling
really is.
rivalry.
Like that's what it is.
Alrighty, let's go.
All right, let's take that.
Let's go to our mini topic for the day, and we'll jump back to questions.
Here you go. Full screen. Look at that. Wow. The two paths: resident spouse versus citizen spouse.
Which now, with visa bulletin, is kind of the same.
It's kind of the same thing, but it's important to know the difference.
Yes,
there's still some
nuances. Actually really good.
So let's just hit it up. So listen. First and foremost, visa bulletin doesn't apply to citizen spouse. So that means you can file anytime and concurrently if you want. Whereas resident spouse, the preference category applies, F2A. I think that's one of two. I'd say there's two.
Yeah.
And then the other one, I mean, you know the other one, the status.
Right.
The person's status is basically as long as they enter legally, an immediate relative petition may be filed and adjust for status. Whereas when you're doing LPR, petitioning for their spouse, F2A, you have to have a status at the time of filing the adjustment of status.
So let's break it down even further for perhaps individuals who don't understand the terminology, okay? When Alexis is referring to visa bulletin and numbers and concurrently file, basically there is no limit to how many spouses U.S. citizens can bring to the United States. Tomorrow, every U.S. citizen spouse...
Well, one per person.
One per person. Tomorrow, every U.S. citizen can get married with a foreign national and petition them. There's no cap.
Let's test that.
Let's do it. But for permanent residents, there is a cap, an annual cap. So that's when you look at the visa bulletin, okay? And the visa bulletin tells you if there are spots available. It just happens to be, we're doing this in March of 2026 right now. There are currently spots available. Exactly. But that's not often nor always the case. It's very rarely the case. I would say that it's absolutely current, right?
Absolutely.
So what that means, that goes exactly into Alexis's second point, which is because there's a preference category and because there's, I keep wanting to say cupo, because there's a
visa available.
Because there's a spot, it's a numbered spot, right? You need to, if you're the spouse of a permanent resident, you always need to maintain lawful status, not presence, status, when and until you apply for adjustment of status. Versus if you're married to a U.S. citizen, it can be done at any time and there's no limit. It doesn't matter if at some point you fell into illegality.
Exactly.
As long as you entered legally.
Exactly. But the runaway is, right now we're in a position that fortunately, with a legal permanent resident,
that's incredible.
You can file concurrently. And for a long time, it was like that. The number of positions must have gone down.
Why are people getting married? Go get married. Go find love.
Found love. So yeah, immediate relative versus family. There's a limited number of spots. The priority date. Check every month, but that's fine. Risk of retrogression, obviously, that only applies to the visa bulletin. Typical wait 2 to 5 versus 12 to 24. I mean, it just depends on the visa bulletin. I see a lot of illegal permanent resident petitions get done within 12 months, meaning they had the interview and approved. I just had a USC petition filed in February, and their interview dates in April. We got it earlier last week. Guess what? That's 2 months. So It just depends. But yeah, these are approximations, I'd say. Filing the I-130 is basically one of two steps. Filing for the adjustment of status is the second. In the alternative, you could always do NVC processing, right? Consular processing. And those are very similar, right? And I think wait times, maybe NVC might be slightly faster, in general.
Yeah.
I would say maybe 6 to 8 months. But you already entered the United States as a legal permanent resident.
As long as your date doesn't retrogress before. So if your date retrogresses after the case has been filed, you're perfectly fine. If you're the spouse of a permanent resident, doesn't matter if the date moves back and forth. It just will take longer for you to get your green card, but you can legally stay within the United States and await that petition. And the spouse can apply for permanent residency, for U.S. citizenship, even if this petition is pending. But then once your spouse goes from permanent resident to U.S. citizen, you do need to notify immigration.
Notify them, exactly.
Actually, there's one more difference.
Between LPR and USC?
Yep. Because I'm dealing with it with a current client now who did not inform me, if he's watching right now, that
How
he became
an
citizen.
LPR?
No, that he became a U.S. citizen.
Oh.
And what did that affect?
During the
children.
The children, yeah.
So
you can elect to keep.
Hold on. Let me go with my point before you interrupt me.
Go for it.
Preference categories can bring derivatives. Mine did the same thing, by the way. Preference categories can bring derivative. They can bring children. Immediate relatives, so spouses of U.S. citizens, cannot.
Exactly.
Children need to file their own petition. Okay. So that is very relevant. If you are married to a permanent resident and you have a minor child who is also trying to get the benefit, do not apply for U.S. citizenship. This is what my client did without telling me. Okay. Because then what ends up happening now, you have to file a brand new petition for the child because it's no longer my resident spouse and the children. It is my resident spouse. It is my spouse and my children. So if you're a U.S. citizen, you have to do one petition per family member. If you are a permanent resident, you can do one petition that covers your spouse and your children.
And so there's two things to consider. The additional time, possible time, and then the money, I think, is the bigger one.
They are not happy with how much money they have to spend.
But CESPA calculation.
Yeah.
So let's say the child is 19 when you started this. Now they're 20. They're going to be 21 soon. Immediate relative. Okay, well, you're immediate relative. So you're good. Once you file that I-130, I-45, you're basically good for the immediate relative child. Even if they're a derivative beneficiary, when it's a legal permanent resident, the calculation is based on the final action date. And so it gets a little bit tricky. And so maybe it makes sense to do it also, is basically what I'm getting at. It's rare where it makes sense to switch on over. So it's something that you always need to develop with a strategy. Look at the visa bulletin. CESPA drives us crazy. But it's completely and absolutely important. Now, everything regarding conditional residency, I mean, that applies to both green card holders or marriage through a green card holder or U.S. citizen. Essentially, if it's approved within 2 years of the wedding or the marriage date, then you get a conditional residency.
Oh, there's another difference. Wow, there's many more differences than I thought there were. If you, now we're talking forward, once you get your green card after conditional, you can apply for you can apply for U.S. citizenship if you are married to a U.S. citizen after 3 years.
After 3.
But if you're only married to a permanent resident, you have to wait the 5 years.
The 5 years. Yeah. Now, if you have the conditional residency, you still have to remove it no matter what.
Correct.
That's the tricky. So we get a lot of people.
Even if you get divorced, by the way.
Even if you get divorced.
You can still do it.
But the big thing here is, okay, I'm married, United States citizen from the very beginning. I chose to remove conditions 3 months before the 2-year mark, which is as soon as you can do it. And I'm getting now to 3 years. I want to file for U.S. citizenship. You still have the conditions pending. And as someone asked earlier, I-751, it's taking about 3 years. So what do? You wait. You have the option, and I have clients who have done this, and I always advise it's discretionary because it truly is. You could file for citizenship. You're going to get that interview probably within 6 to 8 months, we're saying, maybe even before. And the officer is going to say, well, you're here for a citizenship interview. You have an I-751 pending. Maybe they do the I-751 interview there as well. Or they say, sorry, I'm not willing to do it. You need to wait. That's discretionary. It's almost like buying insurance and trying to get it through. So it might work, it might not. But just know those are just timing issues, if anything. But the rest of the process is really straightforward. You know, when you file the I-45, both may file for temporary work permit, temporary travel permit. The biometrics process is the same as well.
There was a question previous. Jump really quickly.
Go back?
Can you file right after the wedding? Yes. You can file immediately after the wedding. I do want evidence of the bona fides of the marriage. Okay.
Exactly.
So like if your relationship started yesterday and you get married today, that might be an issue. But if you guys have been together for a year and you get married tomorrow, I don't mind filing the case the next day because you have a year worth of bona fides of marriage, right? So like, yes, you can file immediately after the marriage. That's a big misconception that we hear all the time. You can file the day after the wedding. I do it all the time.
You could. And guess what? I mean, if you get a request for evidence in 6 months, in a year, whatever it may be, that's fine. You have a bunch of evidence.
And you get more evidence
that you've collected within that time frame. So it's not an end all be all. The automatic upgrade,
as long as you notify, right?
Yeah. Removing conditions, we kind of ran over. And do you need an immigration now, later? I mean, as always, hey, we're professionals at what we do for a reason. A lot of what we provide as immigration attorneys is not just the filing of an application, it's the strategy. What's your expectation? What is our experience with USCIS, right? AI can't really share that with you. AI doesn't have that just yet. That's why developing a strategy is so important. Immigrant intent, conditions, children, CESPA. These are all things that we're considering, and we're considering based on the rules, the regulations, and the current trends, and not based on, just what you find on the internet. But if you need help with any of this, we're here. If you've already started a process in I-130 and you're considering filing adjustment status because you were F2A or F2B and now your priority date is up, contact us. We're more than happy to kind of jump in and finish off that process for you.
We have a funny one. And I think since you're less jaded than I am, he just asked, do you recommend getting married? Just in general.
Hey,
I think.
man, love is love. You live your life the way you want to live it. If you want to get married, get married. If you don't, you don't.
He was like, so do you recommend getting married?
Is this
in general?
It sounds like he might have a
marriage
toxic
for you?
relationship.
Yeah,
I don't know.
It's going to become the love show. Give advice on love.
Love is love. I mean, you want to get married, get married. If you want to save something, you don't have to have a big wedding. You could just go down to the courthouse, have 2 witnesses, and that's it, and then go have a wonderful dinner. There's no right or wrong way to get married or live your life as a married couple for USCIS. And
Alexis supports marriage. Alexis is team marriage, but not if your partner is toxic.
Yeah, just don't.
Which is what
do the world a favor. Do the world a favor and just.
Do you recommend getting married?
Run.
Alrighty. I've got one more question here from Andrea. So that was our little capsule on LPR versus U.S. citizen spouses. Interesting. A lot of little nuances. I agree with. Look, Alex, I like to be very honest with my clients. I'll tell you which cases you need an attorney for and which you don't. I would do a marriage-based case with an attorney because there are little odds and ends. And you do one thing wrong, it could lead to massive delays. It could lead to denials just for small little mistakes. For instance, I'll give you one example, okay? I'll give you one example that I'm dealing with. I dealt with it on Friday. Married to an LPR spouse, and he filed his own I-130, and then he called me in for the adjustment of status, right? Because it's current. And this person marked on the I-130 that they were unemployed while on OPT.
Exactly.
They were not maintaining their status then.
Exactly.
Remember, a spouse of a permanent resident has to maintain status, otherwise they cannot do an adjustment of status. If you mark that you were unemployed during OPT, you were not maintaining status. So it is going to be a huge issue for I-45. That is just one of the several examples that we see every single day as to why I do recommend an attorney. If you don't, for instance, then the subsequent asks, okay, Stephanie, fine. Then what's the case where you don't recommend an attorney? If you are applying for U.S. citizenship and you have the most straightforward case in the world and you do not have criminal history and it's like black and white, do your N-400 by yourself. You're going to be fine. But a marriage-based case, you need an attorney. This is my humble recommendation.
I mean, even on the I-130, when it comes to where you've lived in the last 5 years and things like that, and people are
little things that you think will not be an issue, and they will.
Yeah, it's almost like innocent carelessness, but it's not so innocent when an officer is saying, "Well, you filled out a DS-160 and you applied for a visa 3 years ago, 13 years ago, 23 years ago, and you put XYZ." And so, you have to be very mindful of all that.
Yep.
I've got here, let's just do a quick rapid fire here. Crest Help 1 from Instagram says, and I will translate this. Do you think it's favorable or faster for the countries who are not
banned?
No, okay.
That's definitely not the word.
Yeah.
But
apply for an EB3. Listen, you could still do it because there's a 3-step process and the ban is really subject to the last stage, which is applying for the green card. It takes about 2.5 years to get to that point.
I think what they're asking
doing for the EB3.
Is it better for people that are not from a banned country to apply for EB3? Because she's saying maybe EB3 is going to go faster.
Oh, I think it's relatively the same.
Well, then again, no, that has nothing to do with visibility. No, you're right.
I'm not worried
it's the same
about
thing.
I'm not worried about it.
But to give pro to EB3, we love EB3 because it has such, if you do it right, you really need an attorney to do it right. If you do it right, it has such a high success rate. So yeah, I would do an EB3.
Yeah, exactly. And just to respond in Spanish, she asked in Spanish, he or she, mira, no veo una diferencia, realmente lo veo igual. Y si tienes un buen sponsor y existe esa oportunidad, vamos a hacerlo.
Andrea asks, is there any news about the 75-country pause? Is the embassy still doing interviews in Bogota for EB2 NIW? Yes. In Bogota particularly, we're having clients do interviews every single day for every single one so far. They have not kept the passport. They have basically said, hey, you're pre-approved, you're conditionally approved. As soon as this ban is up, we'll be in contact, we'll collect your passport, and then we'll go ahead and issue your immigrant visa. But yes, they're calling them up and they're doing the interviews as normal, which I kept saying it leads me to believe they're going to take away the ban soon, but it's I'm going to be honest, it's longer than I expected. I thought by this point it would have gone.
Well, they did say 60 or maybe it was 90 days. That's part of the setup. Yeah. And that was in January for the 75 countries. So the assumption is that's why I keep suggesting by the end of April, even though I think it was 60 days. But let's see, by the end of April.
I thought by now it would have been done.
Exactly. So,
and they're having the interviews. So it's like.
I think there's that expectation that there's going to be a change fairly soon.
If they didn't think it was going to be soon, I don't think they would be doing the interviews.
By the way, how does that affect the visa bulletin at that time when they all of a sudden grant a bunch of visas? Oof. So just be mindful.
Yep.
Hey,
file your adjustments in April if you can.
Yeah. Gallo Ortega, hello to the best lawyers. Thank you, Gallo. Hello to you. In your experience in the next months, will there be more approvals for the I-140? I mean, I'm always hopeful. I think we keep adapting. The government keeps adapting depending on the visa classification. I think the biggest question is EB2 NIW. I'm hopeful. I think the officers maybe now have more experience. I feel that maybe about 2 years ago, a lot of new officers were trained on EB2 NIW. You never get a name, but there were a lot of new officer numbers when we received requests for evidence. So hopefully that will lead to more experience, which leads to better odds and more people providing better cases, honestly, and those who qualify. Man, that is a wrap.
Time flies when you're having fun.
Welcome back, Stephanie. We
Thank you.
Are glad you're here, and we're glad you're here.
And after my birthday comes your birthday. What is that?
I don't know.
The music.
Run away. We're gone. It's not a fire, I swear.
See you on Thursdays at noon for the Spanish show. En español los jueves a las 12 del mediodía. Y el programa and the show, the English show, is every Tuesday, 4 p.m. Eastern Miami time. We answer your questions about immigration live and for free.
Air hug.
Ow! I hurt my elbow.